This slide is where literally this presentation arose, because this happens over and over again. This literally, it may happen once a week, where somebody calls my office and says, I'd like to speak to an attorney and have that attorney transfer my home to my children. And when we dig deeper, what we find is that they want to do that because they heard that Medicaid will take their home, and they also feel that if they get it out of their name and into their children's names or name, they will be safe. So this is a misapprehension. It is a misinterpretation of the Medicaid rules. And what we're doing here, and what many mistakes will show us, is that we are trying to solve one problem, but we're creating new problems. So here's what happens with Medicaid. When an individual applies for Medicaid, the house, the primary residence, is an exempt asset. That means it is not countable for Medicaid. When we have a married couple, we can transfer the house from the ill spouse to the healthy spouse, and that is an allowable transfer. There's no penalty for that. And the ill spouse will not have that home counted towards a Medicaid qualification criteria. The problem arises when the healthy spouse either passes away, wants to sell the house, or becomes an ill individual needing care later on. So what people say is, and by the way, Medicaid doesn't take houses. They're just counting it as an asset. They're not going to take it from you. They're just going to disallow you to apply for Medicaid because you own it, if nobody's living there. So people want to transfer these homes to another individual, but really that's not what they want to do. What they want to do is they want to get it out of their name for Medicaid. So the way I like to describe this, and this is probably the longest slide that I have for the day, is there are two what I call buckets of problems that can occur. The first bucket is the most likely problem. The second bucket could potentially happen, and I've seen it happen over and over again. So when we look at bucket one, when we give a house to another individual, what we've done is we've squandered the beneficiary's opportunity to take advantage of what's known as the step up in basis. So I'll give you a very common example. Many of the adult children that bring their parents in or are coordinating the plan with us grew up in the home that their parents are still living in. This means that these homes are very often in the family for 50 years or more. So I'll give an example of a home that was purchased 50 years ago for $50,000. And today it's worth $550,000. If the owner of that home passes away owning that home, leaving it to any beneficiary, that beneficiary does not pay capital gains on that home. So the $550,000 that it's worth now, minus the $50,000 paid, $500,000, that gain disappears. And when the beneficiaries sell that home, they do not pay a capital gain. If the parent has given the children that home during their lifetime, when the parent passes away, the children cannot take advantage of that step up in basis, and they will pay capital gains when they sell the home. Capital gains rate between state and federal is going to be somewhere between 25 and 30%. So that $500,000 gain, that transfer, was a potential $150,000 mistake in my example. Likewise, if anybody in the audience has ever sold their primary residence, they may recognize that they get what's known as an Internal Revenue Code Section 121 exclusion. And what that says is that when one sells their primary residence, defined as a residence that you've lived in for 2 of the last 5 years at least, they can take a $250,000 capital gains exclusion. If they're married, it's $500,000. Again, if the parents have transferred that home to their children, if they want to sell the home either to go to assisted living or to downsize for whatever reason, they once again have squandered the opportunity to take advantage of a capital gains exclusion. And it is once again a potential $150,000 mistake in my example. So that's bucket one. That's a more likely scenario. Bucket two are the potential risks. When one transfers a large asset, whether it's appreciated or not, to another individual, especially a younger individual, what they're doing is they're transferring the risk. So they're transferring the risk that an older person has to a much larger risk profile that a younger person has. Why is that? Younger people tend to get divorced. They tend to have financial problems. They tend to sometimes take advantage of the situation and borrow against the asset. Sometimes, unfortunately, especially as our seniors get older and older, there is a potential for an adult child to predecease the parent. And then we're relying on that individual's will or lack thereof to hopefully continue that home in the bloodline. But very often we know that doesn't happen. It goes to the spouse of that individual. It could go to a friend. It could go to charity. There are so many places that it can go, and the parent has no control over it anymore. So the question many of you might be asking right now is, what do we do? Well, there are a couple of different strategies that we can employ. My favorite strategy for protecting the house is to put it into an irrevocable trust. Once 5 years has elapsed, Medicaid will not notice the transfer. They will not count the transfer, and it will become a non-countable asset. A properly drafted trust will retain all the favorable tax treatments and avoid bucket one problems. And it will also avoid bucket two problems because trusts don't gamble, they don't drink, they don't marry and divorce. So that is a protective envelope that we like to use in order to protect a large asset or an appreciated asset.